Swayam Prabha. Digital India. Educated India.
Welcome to all the learners. In today's session, we will be studying the significance of National Electricity Policy and Plan, and along with that, we will also study the salient features of National Tariff Policy. Now, this is what are the concepts we are going to cover today. We will be covering policy, National Electricity Plan and policy, National Tariff Policy, that what are the salient features in it. We will also critically look into it in order to understand that what has been the thought process of the policy makers to develop the electricity sector. Now, there is a one unique feature what you find under the Electricity Act, and that is the statutory status to policy and plan. Generally, we read that a policy precedes law. So, a policy comes into picture, a policy is being formulated, and then it is followed by law. Now, in this case, what the lawmakers have done, and rightly so, that they have entrusted the task of formulating the policy and the plan, and that task goes along with the implementation of the law. So, you have a law which defines the boundary for the players in the market. Along with that, you also do have the scope of laying down the broader guidelines for those players, and that is what is the significance of policy. It is generally been said that the underlying feature of policy is the flexibility involved in it, the opportunities with the policy makers to revisit and re-articulate with the changed circumstances and with ease, which is not the case when you discuss about, when you analyze law as an instrument to bring in change, because law is passed by the parliament, and in order to bring in any change, it has to again be placed before the parliament, and with the parliamentary process it needs to be approved. So, that necessary flexibility gives a sort of leeway to policy in comparison to law. What purpose policy serves? Generally, it is saying that it is a sort of statement of intention that what the government intends to do. Why this becomes significant for infrastructural sector, I would say, so that it would serve as a guideline, it would serve as a long term vision for the investors. They would understand that what is the thought process going on in the governmental setup. And that is why it has been said that it is something which reflects on the intention, it is a statement of intention. That is what is important to take note of, because certain sectors are very dynamic, and it certainly requires revisiting on a regular basis, because you cannot allow the archaic system to continue. You cannot allow the older version to continue when there are enough changes happening in the market. And that is why this regular revisiting, regular relook is desirable. Policy also presents an opportunity for all the stakeholders to participate on a regular interval, because one for law you can very well visualize that it is a deliberation which takes place prior to the enactment of law. The lawmakers, they deliberate on the nuances of the proposal, nuances of the bill presented on the floor of the house, and then after that deliberation they give a rigid or concrete shape to the proposal, and the next opportunity to revisit is only when it is again brought to the notice of the parliament, which is not the case with the policy. In policy, the policy makers can very well solicit the opinion of the stakeholders as and when situation changes, as and when the dynamics of the market changes, and that is what is the benefit in case of allowing policy framework to be part of a legal scheme, allowing enabling the government to make a policy along with the operation of law on the area concerned. It also adds up to efficiency and quality of government services, because it acts as a sort of check and balance, that the moment it finds that the regulations is going overboard, the moment it has been found that the regulation is, instead of facilitating the activities of the players, activities of the participants of the market, it is causing a bottleneck, then obviously the best way is to assess the situation and then make the changes accordingly, or suggest that what changes are to be done. So, that way it ensures efficiency and quality in the government services, the way the government is required to regulate the market. And one for electricity as a subject, if you recall, we have discussed it in the first module, that this is a subject which falls under the concurrent list, and therefore, it is constitutionally mandated that both the central government and the state governments would be involved in the promotion of this market. And thus, by very nature of the subject requires a regular relook on the front of policy deliberation. And when you look at the purpose what it serves, it attempts to draw a sort of balance between the industry on the one hand and consumer on the other hand, and that balancing somewhere you would agree with me requires sort of regular evaluation, regular assessment, that the fine line balance should always be maintained for the growth of the market. Now, when you look at the mandate which is there in the law, what you find is that section 3 categorically says that the central government shall prepare the national electricity policy, and then it also imposes an obligation on the central government that any such exercise must be an outcome of the consultation between the state governments and the central electricity authority. Why state government? Because of very obvious reason, as I said, the subject matter falls in the concurrent list. State has also been entrusted with a responsibility in the constitutional scheme, and thus we cannot think of a policy, we cannot think of a framework unless and until all the parties are taken on board. And the reason for consulting CEA is that CEA is supposed to be advisory arm of the ministry. Technical experts are member of that, and therefore, what has been suggested through the policy must have the approval of the domain experts. That is what it says. And what is the aim of this policy? If you look at it, it says that the overall development of the market, overall development of the power market, and that is possible only when a sort of direction has been given that how to utilize resources. If you analyze it with the last session, which I took on energy mix, and prior to that energy security, the resources which are available and the utilization of resources for generation of electricity is a very nuanced task, because it is not only about increasing the installed capacity of generation, it is also about efficient and effective operation of the generating units, and it is also about ensuring robust infrastructural setup at the other end, transmission or distribution. Apart from that, whether the resources which are being used, they are serving the larger purpose of clean environment or not. And not only clean environment, but also the financial health of the country. If the country for energy and for production of electricity heavily relies upon import of fuel, then it would certainly do it at the cost of financial health. And therefore, a constant search is required to look for the resources indigenously, which I highlighted in the last session. Apart from the policy, which is a responsibility of the central government to draft and to prepare, the law also provides for making of the plan, National Electricity Plan, and this plan is to be made by Central Electricity Authority. And it has been suggested that let the plan be made once in 5 years, and it must have an approval of the central government. This plan is being made considering the interest of the stakeholders, that how the market would perform in coming years, how the market is growing, what shall be the necessary steps for scaling up the investment. All this needs to be planned, and therefore, it has been suggested that let the plan be an outcome of a dialogue. Let it not be an outcome of imposition from the top to the players of the market. And that is why it suggested that whatever plan the CEA is being formulating, it must have the necessary input from the stakeholders. So, CEA has an obligation to invite suggestions, to invite objections, and not only from the one who are directly participating, the utilities, the generating companies, the licensees, traders, but then it is also suggested that they need to also consult the public. Public can also give, because at the end of the day it is for consumer interest. So, consumer interest needs to be fulfilled. In pursuant to the mandate of section 3, just after 2 years of the Electricity Act 2003 brought into existence, the government has prepared the policy in the year 2005. The policy is being prepared considering that what shall be the roadmap for the growth of the power sector. because providing the guidelines in the form of statutes, in the form of provisions in the statute is one way of disciplining the participants. But then keeping the sort of flexibility of accommodating the views of the participants is another important approach, and that is what the policy suggests, and that is why it says that it is a sort of roadmap that what has been aimed to be achieved under the law, how that is going to get implemented. And that is what exactly the policy suggests. It prescribes the way. So, what 2005 policy aims? It promises access to electricity for all households. It says in next 5 years. Not very difficult to accept that too ambitious was the target, and we have seen that it has not been fulfilled. And then it was also suggested that let there be a reliable supply of electricity, quality supply of electricity. There shouldn't be any blackout. There shouldn't be any voltage fluctuation. Otherwise, that electricity is of no value for the consumer. It suggested that let there be a reliable and quality supply with a reasonable price, at the reasonable price. And this is something which is to be met by 2012. That is what was suggested in 2005. Per capita consumption in India is not really very comparable with the developed countries, and that is why it suggested that per capita availability should be over 1000 units by 2012. And along with that, it also suggested that we cannot leave a large section of population which is living in on periphery, the marginalized section, and therefore the policy suggests that 1 unit per household per day should also be the target. And it is important to note that this target, being a part of policy, is a testimony that public interest has a role to play in the development of the sector. It is not only about increasing the generating capacity and ensuring that the one who has the ability to pay is getting electricity. It is not only about that. And then also policy suggested that let there be a revamping done to strengthen the financial position of the licensees, because unless and until we make the generation of electricity commercially viable, the desired growth in the sector is not attainable. It is not possible. That is what it says. Apparently appears that 2005 policy lays down a roadmap and tries to give a direction to the regulatory bodies, to the utilities, promises to the consumer. But then in 2005 policy, somewhere the concrete steps that what should be done for fulfilling that promise was missing. The terminologies which were being used were like efforts are to be made. Now, how those efforts are to be made was missing in the policy. And that is something which is important, because unless and until you suggest something on a very concrete ground that what is to be done, how are you going to ensure electricity to every household, how are you going to increase the consumption, It is very, otherwise it becomes a sort of kind of ambitious document only. There is no design to implement it at the ground level. The policy also suggested lot many initiatives are to be taken by the State Electricity Regulatory Commission, knowing very well that as far as the capacity, as far as the ability is concerned, they are not placed in such a situation where they can undertake those responsibilities or tasks. They have been asked to decide on the transmission charges for open access. They have been asked to decide on the regulation for a grid interconnection for captive power plant. They have been asked to design for the grid codes at the intra-state level. Now, it is important to remind that much of the malleus in the system was because of the non-performance of state electricity boards. And the reform in that started in last 2 decades only, when you consider 2005 as the baseline. So, interesting, so much of responsibility on the Regulatory Commission was not really welcome step. Other important aspect was that coal was continuing to be a preferred fuel for generation of electricity, and the large segment was coming from coal based thermal power plant. But then there were challenges with regard to efficient supply of fuel to the thermal power plant, because coal mining was heavily regulated by the government, sort of monopoly of the government. And therefore, nothing was suggested that how that is something which is going to be addressed, how supply side constraints are going to be improved. After 2005, an attempt has been made to revisit, relook at the policy. Now, we have a draft of 2021, which focuses on multiple aspects, and not very difficult to visualize, not very difficult to imagine, not very difficult to convince ourselves that why this approach of widening the ambit of policy document, because in last 2 decades or so, enough technological improvement has taken place. Renewable has been seen as serious competitor of conventional sources, and thus it has been suggested that let there be a new outlook to the policy dimension. And that is why you find that the 2021 suggests for facilitating retail competition. The idea is that you allow the market to be operational in fullest sense, so that buyer and seller, they will have complete freedom, and more is the interaction between buyer and seller, higher is the satisfaction of the consumer. That is one reform which is still awaiting in power sector in this country, reform at the retail segment, where as a consumer I should have a choice that whether I should buy electricity from licensee 1 or licensee 2. And you can very well visualize that if such choices are there with the consumer, then it will certainly guarantee the growth of the market, because consumer plays a very defining role. Policy also suggested for energy mix in a big way, where renewables will have also considerable share, And 2021 policy also suggested that let there be a complete reform at the last segment of the power market, that is of distribution utilities or distribution companies, because distribution utilities or distribution companies, they have not yet completely been reformed, and that is the reason why you find that the vision has not been fulfilled, the market growth has not been completely accelerated. If the distribution companies are getting that kind of choice, if there is a necessary reform brought in the distribution segment, no denial, it will improve the financial health of the entire segment, because ultimately the cost of electricity is being charged on the end consumer, and subsidy cannot be everlasting proposition under the law. It has to be over a time be brought to a minimal range, only to give it to needy people. It also focuses on quality, reliable and affordable supply and service. Much has been achieved by ensuring grid discipline, which we would be studying in detail in the coming session, that how the grid discipline has been achieved by fixing a solder range of 49.5 megahertz to 50.2 or 3 hertz. So, that is what has been suggested, and then it says that let there be a strong regulatory governance, so that indiscipline cannot be allowed. And as we are promoting renewables, it is certainly suggested to have environmental concern on all the planning, because anything which has been planned, it must be sustainable for 50 years down the line, and climate change is really emerging as a very big issue for the mankind. Now, in this 2021, it has been suggested that let the technology markets, metering be considered as an important factor. Supply of electricity should be based on the consumption, and the revenue should be asked as per the consumption, and that is why metering becomes important. Technology is important to make the generation cleaner. Technology is important to make the supply very reliable. Real time trading is possible when you have a robust technology in place, and obviously the free market is no doubt a boom for this sector. But then still the situation is same if you compare with 2005, that coal is still considered to be a preferred source. Why preferred source? Because of the cost. Though, as I said, that renewables are also becoming competitive. So, obviously, in time to come, there will be larger presence of renewables in the power market. We will get more generated electricity from renewables than the conventional sources. So, cost factor would not be a kind of guiding factor or a compelling factor, I would say, in this case, because the cost factor we are going for coal based. and we import coal because our coal is not very clean in terms of the final value of the raw material for generating electricity. We get a lot of waste from that coal. We import it from Australia and other countries. Now, on the issue of safety concern, it is 2021 policy also suggests that there is a need to minimize the accidents which are taking place because of electricity. Human lives are being lost, and not only human lives, even life of animals are at stake because of unplanned wiring, because of unscientific wiring, and that is why it has been suggested that let that be also be considered. As I said, that the plan is something which has been prepared by CEA every 5 years. Now, this is a document on which the assessment of the market happens, and if you look at the language of section 73, which lays down the responsibility, which identifies the function of CEA, it says that it has a function to formulate short term plan and a long term perspective plan. So, 5 years short term plan and then 15 years perspective plan for the development of the power market, for the development of electricity system. So, this plan helps the generating companies and utilities to plan the investment, to build a strategy that how they would be planning their growth, how they would be channelizing their resources in time to come. And that is why it in the plan it has been suggested that what is the forecast in a short term sense and in long term sense, so that a defined kind of projection has been given. There should not be any kind of blind drive here. Plan also suggests augmentation of capacity. It also suggests that environmental considerations are to be taken into account. If big thermal power plant is being established, then what will happen to the displacement issues? And then plan also talks about energy security to make less dependent upon others, and also about fuel choices. Then now national electricity policy and plan, and then section 3 also talks about the tariff policy. Now, tariff policy was formulated in 2006, just after a year when electricity policy was being notified. In this, it was categorically suggested that we need to promote renewables, because when you look at the salient features of 2003 Act, you would find that that is more on electricity being generated through conventional sources. On renewables, there are very scant provisions. We will have a session on it, that how renewables are being governed under the Electricity Act. So, I would say that those scant provisions are now getting supplemented with this tariff policy, because they are not to be read together. And therefore, it has been suggested that the Commission shall determine a certain quantum of electricity to be procured from renewables in order to promote, in order to put an obligation on the distribution utilities that you have to buy. And for that, it was suggested that for determination of tariff, they can always go for preferential tariff. They can also make what tariff policy suggests, that you make a plan so that they are to be placed in advantageous position, preferential tariff, advantageous position when you compare with rest. Mandate of the policy itself. And then it says why it is to be done, because then only they can be competitive, otherwise they cannot be a competitive one. And ultimately, it is suggested that procurement is to be done on the basis of competitive bidding. If you allow competition to play a role, obviously the consumer welfare will get addressed. But then in this, it has been suggested that public sectors are to be exempted for 5 years or till the time the regulatory commission is satisfied. Now, this has some kind of shortcomings, because if you are allowing the market to be open, then you should also allow public sector undertakings to participate. One can really understand the concern at that point of time, because these were being completely owned, regulated by the government prior to 2003 Act. Obviously, in 1991 unbundling was suggested, but then there has to be a sort of same level playing field given. Then multi-year tariff framework was suggested in the tariff policy, which was a very good step, because multi-year tariff in a way gives a conviction to the investor that if they come and invest, they will have a return. Return is assured in the form of multi-year tariff. So, that was a very welcome step. It was also suggested that to bring in transparency on the transfer of subsidy, that let there be identification of targeted beneficiaries in a very meticulous manner. Let price not be a factor, let consumption be a factor for identifying the beneficiaries. And then it was also suggested that the tariff should have a kind of two components. One is the fixed one, the other is the variable charges. And it is suggested that let it be get implemented for the large consumers who will be consuming more than 1 megawatt and above. This 2006 policy has been amended in 2016, where it has been suggested that let every village which are remotely located in this country be given 24/7 electricity supply. That is what it says. And then further it says that as the rural electrification largely is going to be achieved through mini grid and micro grid, let there be also a plan that the electricity from micro grid can be supplied to the main grid. That is also is allowed. That is also has been suggested. This is for a sort of sustainable model, that if more generation is happening, let the electricity be fed in the grid. It has also been suggested that waste to energy plant be promoted and procurement of electricity from those plants are to be made mandatory. And this was aligned with the plan, aligned with the agenda, the mission of Swachh Bharat. So, waste to energy plan was a good suggestion that any electricity which is being generated from these kind of plants, the utilities will have a responsibility also to procure electricity from that. And then it has been suggested that hydropower projects which will be awarded under cost plus basis are to be exempted from competitive bidding. This is again to minimize the reliance on imported fuel. This is about the support to the indigenous sources. And then it was said that interstate transmission charges and losses for renewable is to be exempted. The idea is to promote renewables, idea is to make them more competitive. One may ask a question, why only wind or solar generating units are being given exemption, why not other segments, why not biogas, why not other resources from where we get energy? That is certainly a question. Tariff policy of 2016 also says that the power plant are allowed to sell surplus energy in spot market, the real time market, that is what is allowed through the power exchanges. And this you can very well visualize that this can give necessary push, necessary impetus, necessary kind of acceleration in terms of becoming financially strong. And then it was suggested also that renewable purchase obligation from solar should be increased to 8% by 2022. That is what it also suggested. 2016 tariff policy further was amended, amendment was proposed in that, where it says that all future requirement of power is to be procured through competitive bidding by distribution licenses. This is in a way an attempt to push necessary reform in the retail sense, in the retail market sense, that you allow distribution licenses to procure it through competitive market, then certainly we will be having more retail consumers in the market and real time trading will become. Another important suggestion was made is that any change in law, if suppose the government is changing the tax structure, some cess structure, then that can be automatically part of the agreement and that need not be approved by the appropriate commission. And then it was suggested that return on investment becomes an important feature, but for that it was said that return on investment must be planned in such a way so that there will be enough money at the hand of the investor to invest it back in the growth of the market, and at the same time the consumer interests are also not to be hampered because of that. This is I will just indicate two cases which highlights the significance of the policy. Reliance Infrastructure Limited versus State of Maharashtra, wherein the question was being raised that what role the policy plays when the appropriate commission fix a tariff, and then the court said that tariff fixation is primarily a legislative exercise. So, if it is a legislative exercise, then appropriate commission must give due consideration to the policy. If the appropriate commission ignores it, overlooks it, perhaps it may be fatal, it can be very well taken up in the code of law. This is another important case, again Century Ryan versus Maharashtra Electricity Regulatory Commission, decided by the Supreme Court in 2020, wherein the court said, and I read, that this is something where the commission, while determining tariff, is statutorily guided by the policy. Now, this word statutorily guided, which I have underlined, is to draw your attention, is to stress on this fact that this is what is the benefit of giving a legal context to policy making exercise. And court said that if the regulations are being framed overlooking the policy prescription, then such regulations can very well be assailed in the court of law, and that can be done by reviewing the regulation, and reviewing the regulation can happen only in the code of law. It is said that tribunal cannot review the regulation. So, regulation is to be reviewed only either in the High Court or in the Supreme Court. Appellate tribunal cannot review the regulation. But what is important to understand the significance of section 3 in the scheme of Electricity Act, what is important to understand that how the very provisioning of policy making exercise in the Act gets reflected in the observation what the court has given in Century Ryan. It says statutorily guided. So, it is not merely a wish that you are advised to follow. No, it is not you are advised to follow, you are mandatorily advised to follow this, and that becomes very significant in the language of law. So, this is what is the significance of electricity policy, tariff policy and electricity plan. Thank you very much.